Good morning. I thought I would do a video after my court hearing on Friday, the 23rd of May 2025 at Plymouth County Court against Act Credit Management, who is a debt collection agency. Firstly, I'd like to say thank you to everybody for all the messages of support, asking me questions, asking for help. It's really hard to reply to everybody. My inbox was rammed, which is absolutely wonderful. I just don't have the time with everything else that's going on to respond to everybody to help. So I wanted to do short videos of the process that I followed. So first thing I'm going to say is you should not be ashamed that you are in debt or that you are in a situation where you can't afford to pay your bills, because the government have put us here. We are really struggling to pay ends meet, pay our bills, pay for fuel, and have any ounce of savings to live from, to do something that we like to do in our own lives. So first of all, I think there's a huge amount of shame attached to saying that you're in debt or you've got a debt collector. I couldn't care less, and I shout it from the rooftops because that's who I am. I've always been out there. I've always been someone that just says it as it is, which, I've learned over the years is not always a good thing. So let's go to the debt collectors. So here's my court bundle, Plymouth County Court. This is the claim number that I submitted. This is myself, the claimant. I'm the litigant in person. I don't have any legal representation. And this is Act Credit Management, the defendant. So this is my little bundle that I put together. Well, not myself fully. I will explain shortly. So let's just go right back to the beginning. You get a letter in the door, you open it and it's from a debt collector. You instinctively go into fear, shame, panic. How am I going to pay it? Is it going to affect my credit rating? All of these awful things. And something we never do, well, I did, but something we never do is, well, how did they get my data? How did I agree to Act Credit Management? Having my address and knowing where I lived. Who are these people? So I started doing a bit of digging. So last year I left my job as an NHS midwife. I had a work car under the NHS Fleet Solutions at my hospital, which was linked to Northumbria Hospital. My agreement was with my employer over the variation of contract agreement, and my car was deducted from my salary. That's how it worked. When I left, because I became a whistleblower for patient safety, midwife safety, I was threatened with my life that I would go missing if I continued to whistleblow. So as you can imagine, I'm in my own home, worried that people have got my name, my address, my telephone number, and now I'm thinking, how on earth have these people got my details? So what I decided to do was ask the hospital for a data subject access request, which was on the 17th of July. Now, I first received a letter from Act Credit Management on the 19th of June for £1,223. Now, that's fine. I do have an agreement with the hospital that the remaining balance of my car, if I leave in contract, is payable by me. I've never disputed that. What I'm disputing is that university hospitals have given my data to an independent corporation, Act Credit Management. On Companies House, they have their own company number, and they're authorized by the Financial Conduct Authority. So how have these people got any authority to enforce a debt on me that I didn't have an agreement with them? That was my first question. So I was absolutely fuming and distressed, distraught. I was angry, I was hurt, I was so upset that my own employer, who pushed for data protection against patient safety, which is absolutely paramount. So when I was a midwife, every year I would have to do a GDPR and data protection e-learning, and I would have to pass that to have my yearly training signed off. So how can a woman who's in labour, her mother ring up and ask, how is my daughter? Is she safe? Is she well? And I can't even confirm nor deny if she's on the ward or how she is. How can I not provide that information, but yet my employer give my name, my address, my mobile number and my email address to a completely random company who they probably don't even know, and I don't know? That was my question. So I sent a letter to ACT Credit Management and to University Hospital Plymouth. And what I was trying to do was bridge a gap together of the information that they shared between each other, how that came about, why, and where in that is my consent or my permission. So what then happened next was ACT Credit Management continued to enforce the debt without stopping. University Hospital Plymouth denied giving me a data subject access. They say that they've sent it via email, but every file is encrypted and I can't open it. So, pushing on from that, I've given this a lot of time to unfold. Now, what I did find was my variation of contract, which is inside my bundle, and it is exhibit 4 of my bundle. So, I say so a lot, I've just realised, but we'll just keep going. When I went to court on Friday, the defendant wanted a strikeout on 3.4, specifically 29 and 26 for due process, and 13.3, they wanted to set aside the judgment of the CCJ that I had issued against the company. So you know when you get letters from St Catherine's Business Centre and they say, we're going to issue a CCJ, and you get a CCJ put on your account. I did that to them rather than them doing that to me. So the process that I followed was I sent a notice of conditional acceptance to the debt collection agency. And in that I asked for specifics. And I was asking for information that they hold on me and how they obtained the information. And I was also saying, okay, I accept your terms once you provide me with X, Y, and Z. And X, Y, and Z was my data, the legally executed deed of assignment, which is the assignment that the debt collector needs and requires to buy or purchase my data and debt from University Hospital Plymouth. So I was looking for this document. It didn't arrive. What did arrive was an array of letters saying, thank you for your complaint. I never raised a complaint. So if you get sucked into the complaints procedure, they say they've exhausted their internal processes, which is not what I asked for. And then they think that they're a hand up on me, which they were not. So after sending a notice of conditional acceptance and then a data subject access, I then sent a vulnerable person notice. And a vulnerable person notice is that you would struggle to enforce a debt under the 77 of the Taking Control of Goods Act, National Standards 2014. And my vulnerabilities are that I've got type 1 diabetes, I'm now unemployed, I've had horrific mental health attached to my diabetes, and people think I look great here, but you don't see me behind the scenes and what goes on in my life. It's much different to where I am. This is my drive to try and make my life better. So I sent that on the 15th of July. I then sent a cease and desist notice, which you would struggle to argue if you continue to ignore. And a cease and desist is stop doing what you're doing until you've sent such and such documents. I'm not going to engage with you. Now, because the debt collection agency didn't engage, I then sent a notice of intention to prosecute. And I was going to prosecute for breach of GDPR. Now, the breach of GDPR is the General Data Protection Regulations and the Data Protection Act 2018, which is set up to protect you and your data. You are the data subject. You are the subject. I'm asking for my data. Now, nobody can hold or withhold data on you without your permission. And they equally can't conceal it because it belongs to you. So you can ask anybody for your data. You could ask a company. You could ask McDonald's for all the video footage. You could ask Tesco for the facial recognition, which is something that you all need to look into with Pete Wilson at Check the Matrix. You could ask your company. You could ask a DVLA, anybody you can ask for your data subject access. It's a simple letter and you can find many templates, and then you send it off, and within 30 days they have to send it to you. If they do not, you are entitled to claim against these people for withholding your data. So that's what I did. I sent a claim form to the small claims court for £5,205. 5,000 was the claim and 205 was the amount to issue the claim form. What then happened was I made an error on the claim form. I was addressing it to the CEO, Sally Hodgkins Lewis. I appreciate this camera's backwards. However, Sally Hodgkins Lewis is the director and has always been in capacity as the director at Act Credit Management Limited. So all my letters were addressed to her and that address that she works at. So I submitted the claim form to her and realised I should have submitted it to Act Credit Management. So under the proceedings 3.4 for due process, the defendant, wanted my claim struck out because I didn't start the process all over again with all the letters that I sent to Act Credit Management, because I'd now changed the claim form from Sally Hodgkins Lewis to Act Credit Management. However, my argument to the judge on that process was I followed due process and it isn't actually going to make any difference in this situation in the court because I did address it to the same person at the same company, which were received, as you can see from the evidence provided in my bundle. We have got to this place with or without a change of name and we need to remain there. So the judge agreed not to have a strikeout for that reason and actually said I followed process. So I was really pleased with that. I was almost jumping for joy under the table. The other point at 13.3 to set aside the judgment. So what happened when I submitted the claim against Sally Hodgkins Lewis, I discontinued that claim and informed the court and the defendant that I discontinued, and I resubmitted a new claim under Act Credit Management. Now, because the company didn't receive the new claim form, apparently, I was able to issue them a judgment for £5,205. And this is what they get against you all the time. So they will say, you didn't pay your parking fine, we've got a CCJ against you. Now, you can still argue those, by the way. So this is what I got on the 29th of December, 2024. So obviously I was thinking, what's going on? Have they missed it? So they argued in court that they didn't receive the original claim form. And they were now arguing to have the CCJ set aside. So my arguments during my case were the follows, and I can read these to you. I was putting in for a UK General Data Protection Regulation, the Data Protection Act 2018, Protection from Harassment 1997, the Financial Conduct Authority Handbook, Conc 7 and PRIN particularly, and Equity and Clean Hands Doctrine. Now, these laws that were supported by case law of Halliday versus Creation, Lloyd versus Google, and Van Linn Developments Limited versus Peleus Construction 1969 1 QB 607. Now, my argument in the case was that the claim arises from the defendant's unlawful processing of the claimant's personal data and continued enforcement activity in the absence of a legally executed deed of assignment. Now, that is supported under the Van Linn Developments case law. And during a pending county court claim, the defendant has approached the court with unclean hands and in breach of equitable principles. So, when I went through all of my particulars of my claim and my argument, I was asking the judge to seek part of the merits of my case. Now, we weren't there to hear the whole case because the defendant hadn't supplied a defence to argue against. They had just presented to the court that they wanted, 1, a strikeout, and 2, they wanted the CCJ set aside. I had my chance now to provide my side of the story. So that was the defendant's side. So I went in to the judge and said, Your Honour, thank you for having me. I'm a litigant in person. And I wanted that minuted that I'd said it. I then asked the judge, I told the judge to start with that I had been a midwife in Plymouth and I left to whistleblow due to trying to raise internal safety concerns with the CEO, and they were ignored. So when I whistle blew, one of the directors called me up and told me that I would go missing overnight for whistleblowing. Obviously, I explained that that was so horrible, and I didn't go running. I haven't been running since. I just feel so nervous about going out at night. I'm looking over my shoulder a little bit more. It's not been very pleasant. However, I asked the judge if he could then turn to page 26 of my evidence bundle. And I explained to the judge down at point 14 and 15 that all charges levied against the employer under the terms of the lease in respect of mileage, wear and tear, mistreatment, neglect, would be met through a direct deduction from my net salary. And in the event that your employment ceases before the end of the contract period, then my net pay would be deducted after returning the car to the organisation. So nowhere in here does it say that I gave permission for my data to be shared. That is a very clear data breach. I then asked the judge to go to exhibit to page 70 of the defendant's bundle, which I had on my laptop. Now, I'm not printing off 134 pages because I don't have the money to do that. And I asked him to look at visually that on page 70, the defendant had written to me at my NHS email on the 11th of May, but I had left on the 7th of April. The defendant then, on page 72 of their bundle, proceeded to email me at my NHS email, again, not in use. By the 11th of June, which was page 73-74, the defendant now started emailing my private email account and texting me, which was in the defence. I said to the judge that nowhere in my variation of contract did I agree for that to happen. It doesn't matter what it is, there has to be permission. Now, Enterick versus Carrington, 1765, you have to give permission for you as a subject for anybody to come into your home. It doesn't matter whether it's through the post, whether it's walking, you have to give permission. So I gave a good case, and I said to the judge, I appreciate it's not a full hearing. However, based on this, the defendant hasn't provided the data subject access request on two occasions, and it's got to this extent. And clearly the defendant doesn't have a defence, and we're here today and it's wasting everybody's time, and I've had to learn all of this for the matter of this case that could have been settled quite simply by them providing me with the documentation. Lovely, I'm going to give a shout out to lovely Peter Wilson from Check the Matrix. He's on YouTube as Return to True Democracy. He helped me put this bundle together. Now, I didn't meet Pete until probably October, I think it was. So I'd already done part of the process and the learning myself, but Pete enabled me with a lot of confidence to put this together for the court. And by God, did I need it. So, as we know now, the judge set aside the judgment, which is really what I wanted, because I want to have this in a courtroom to argue it out and hopefully have some sort of case law and set a precedent that debt collection agencies cannot enforce without your permission. That's pretty much as simple as it is. On the other side, he didn't strike out my case. So he didn't see it as weak. He actually said, although I have not addressed the merits of the case, I have listened to every party today, and this is potentially a clear violation, I think he said serious, violation of data protection breach and harassment. Now, harassment is 2 or more contacts without your consent. So if you've said, please don't contact me, and you get 2 or more, then you can call the police about it. It is a criminal offence. The judge then ordered, may I just add, the defendant asked, she was very unorganised, and she asked me why we were there in the waiting area before court. She said, I don't really know why we're here, and I didn't. Again, I don't know if I'm supposed to tell them. I don't know what I'm supposed to tell them because I've never walked this walk. So I just said, look, we're here because of a debt over, data protection, and your client hasn't brought any defence. So that was it. She didn't look very organised. I felt quite sorry for her because, she got She just didn't look very organised anyway, can I say the least. So she was filing through the file like this. And the judge did say I was eloquent and intelligent and presented myself well in the court. So I don't think that went well, that she was so unorganised and actually said, I don't even know why we're here, and then couldn't turn to the right page, and it just was very unorganised. Anyway, that is pretty much the case. I had 3 amazing people who drove 2 hours to be with me, to support me in this court, not to be, bully boys or anything, but these are 3 grown men who I've been in a fraud group for bill fraud for a while, and they drove all the way down to support me in this court. It was absolutely fantastic. Not only that, I saw someone I knew on the door when I went in, so that eased my anxiety. And then on the wall was Lord Denning engraved in the wall, which I used in the case. So there was loads of really, really positive affirmations that I was supposed to be there. Now, the judge did say at the end, he went to make his order, and the defendant said, Judge, I've got a draft order from you. So you can give on both sides a draft order of what you want, and that the judge signs it to make it easier for the judge. I didn't do that because in reality I wanted a hearing. Now, the defendant said, here's a draft order, and he said, I'll write my own, thank you. So this was a really, really, really positive experience. It was stressful to get there, but it was very positive. The judge has ordered that the defendant has to provide a defence by the 6th of June, which will then, if the defence is strong enough, it will go to a trial, and we will then have a normal trial. If they do not, the CCJ of £5,205 will be reissued against the defendant, which I will be awarded. So all in, it's a great win. It's really important we feel empowered. Don't feel shame that you're in debt. Don't feel embarrassed at all. So many people sit at home and worry about this. You're not alone. You're not the first person. And there's people out there trying to push this process so we can help you. And I'll be honest, I've been shafted by the NHS for 10 years, bullied, horrendously harassed. I was a fantastic midwife, and this was the bloody last icing on the cake, to have my data shared without my permission. And that, ladies and gentlemen, is a breach of the law. Take care.